investigation. They continue to represent them. They represent them. I received notice from the state that they were refusing to be interviewed absent a court order. So they will be represented by that firm, my firm, as of once the parties have to come before Your Honor for an order for deposition. And I have every reason to believe that they will continue to be represented by Puget Law Group through the trial process. This creates a conflict, which is not so much a conflict with respect to confidential information, although that may come up as well, but a question of loyalty. And does the attorney have a duty of loyalty to both clients? And when that's the case, the conflict of interest is unresolvable, particularly when it is in the same matter. I think the rules are relatively clear that if the conflict is outside, maybe it's dealing with a family law case and a criminal case, or a prior representation of a client whose interests are contrary to the current client. There's no question that in this case, the conflict exists, and the only way, and it actually, I was going to say the only way to avoid it would be to get the waiver from all 6 parties. But the rules actually don't even permit that in the circumstances when it's in the same matter, when it's in the same case. So waiver wouldn't be an issue. The court may have looked at some of the case law recently or on this. The issue of whether it's brought up pre-trial or during the trial actually matters. We're 4 months before trial. So I'm making this in a timely manner, letting the court know that I can't proceed as the attorney of record in this matter. I will let the court know that Sheriff Troyer has engaged new counsel. We will file a substitution of counsel next week. They just weren't available. I spoke to counsel earlier today, said yes, we're coming in. All the arrangements have been made. They just don't have, I think she was out of the office and couldn't file the MOA today. So this will not be a case where Your Honor has to come and have a hearing and saying, Sheriff Troyer, where's your attorney? I let Mr. Sheeran out with your promise that you would get one. No, new counsel has been retained, and we'll file a substitution on sometime next week. I was going to say Monday, but obviously not. If the court has any other questions, I'd be happy to answer them. I'll let the court know that I discussed this with the state's attorneys, and they understand and recognize that it is a conflict and that I have to withdraw.
You had a second motion also to continue today's hearing?
Yes, sir. I think that I'm asking the court to continue today's hearing because with the duty of loyalty being the primary issue, not the duty of confidentiality, I think it makes the most sense for Sheriff Troyer to have counsel that he is confident will be representing him to the best of their ability without any conflicts. I've spoken with him about this. He is in agreement. He thinks that new counsel would be appropriate, and he's asking the court to grant that motion as well.
Thank you. Mr. Hillman.
Thank you. Your Honor, the state doesn't have an objection to Mr. Sheeran withdrawing from the case, but not until after the court hears the state's motion today. And for that reason, the state opposes the motion to continue and would ask you to deny it. Mr. Sheeran is going to be working for this new firm starting on Tuesday, but as he stands here today, he does not have a conflict, and he only has one duty to one client, and that's Sheriff Troyer. So I do believe that he can go forward and represent Mr. Troyer at this hearing. Additionally, the only evidence that the state's relying on for this motion is evidence that was presented at a civil anti-harassment hearing that took place on June 6th, where Mr. Sheeran was the only person in the courtroom here that was present other than his client. So I think he's best suited to represent Sheriff Troyer on this matter, and he, as of today, is conflict-free. He doesn't have a conflict until Tuesday. I would also point out that this is, both an administration of justice and a public safety issue. The state's alleging that the defendant violated your court order to not have contact with an important state's witness, and that he did so in a manner that was intimidating to this witness. And so it's not something in the state's opinion, that can be put off for a few weeks, and there is a sense of urgency. And because Mr. Sharon doesn't have a conflict today, is best suited to represent Mr. Troyer today since he's most familiar with the evidence, and because of the urgency that I just mentioned, we should proceed with the hearing today, and then after Your Honor rules, or after the hearing concludes, the state has no objection to Mr. Sharon's motion to withdraw.
Mr. Sharon?
I find the idea that I don't have a conflict in today, but I do as of Tuesday morning, a little specious. And I'll put it for the court this way. If Mr. Hillman had taken a job, or any assistant attorney general had taken a job with a firm representing the Boeing company, and there was an argument contrary to the Boeing company's interests on the Friday before they started the following Monday, I don't think the Attorney General's office would be too thrilled with that attorney handling the case, because it's a duty of loyalty. And I just don't think that we are in a spot where we should be pushing those bounds. It is unnecessary, like I said, when new counsel has been retained.
Thank you. At December 3 of 2021, at the pretrial, the state sought to have this trial date set in February, March of this year. The court set the trial date for July 11 of 2022 for next week, granting a defense request, Mr. Sheeran's request at that time, for additional time. Again, this is in December. The state had asked for a trial in February, March, and Mr. Sheeran said he needed more time to prepare, and the court granted the defense motion. Speedy trial waiver was signed, and the court set the trial for July 11. On March 11, 2022, the pretrial, second pretrial, the trial date remained July 11, 2022. The court's next pretrial was May 6, 2022, and at that time, Mr. Sheeran, on behalf of Mr. Troyer, moved to continue due to perhaps up to 20,000 pages of discovery that Mr. Sheeran had received or was in the process of receiving through public disclosure requests. The state objected to continuing the July 11 date, but the court granted the defense motion to continue and set the trial date, which is currently set for October 31 of this year. At that time, we had a long discussion. Was October 31 realistic, given the defense need to properly prepare and the discovery and the information that it had received? And Mr. Sheeran assured the court that he would be ready to go by October 31 of 2022. Today, Mr. Sheeran moves to withdraw as Mr. Troyer's lawyer, so Mr. Sheeran can take advantage of a job opportunity. This motion is governed by CRRLJ 3.1E. That rule provides that once a criminal case has been set for trial, a lawyer shall not be allowed to withdraw except, 1, upon the consent of the court for good cause shown, and either 2A, upon substitution of another lawyer, or 2B, upon the defendant's knowing and voluntary decision to proceed without a lawyer. At this time, while Mr. Troyer has, it sounds like, retained a new lawyer, which is fine, that new lawyer has not entered a notice of appearance in this case, and so at least from the court's perspective, that lawyer does not exist in this case yet, and Mr. Troyer is not requesting to proceed without an attorney at this time. Based upon the court rule requires this court to deny Mr. Sheeran's motion to withdraw as counsel because there is not a substitute attorney present and available for today's hearing. Now, I want to make clear that the court has no desire to unnecessarily interfere with Mr. Sheeran's job and employment opportunities. He should be free and is free to do what he thinks is best for himself and his family. So, this motion today to withdraw is denied without prejudice. The court will entertain Mr. Sheeran's motion to withdraw if 1, Mr. Troyer retains new counsel, 2, new counsel substitutes in this case, and 3, new counsel affirms to this court that they will be prepared to proceed to trial on October 31, 2022. So if those 3 conditions are met, the court would be willing to entertain an ex parte order and would then grant Mr. Sheeran's motion to withdraw. Otherwise, if those 3 conditions are not met, Mr. Sheeran will remain Mr. Troyer's lawyer at trial. So therefore, Mr. Sheeran's motion to continue this hearing is also denied. Mr. Sheeran, anything else you'd like to say on this matter?
I understand the court's ruling, I'm not arguing with it, I just want, the court appeared to rest its decision based on the substitution issue, while skipping the first consent of the court for good cause. And it seems like the court's finding that while the state agrees that there is a conflict, given the stipulation or requirement of new counsel to be willing to tell the court that they're going to be ready to go October 31st, the conflict would not be good cause.
No, what the court's saying is today there is no conflict. And you have a sole duty, Mr. Sheeran has a sole duty to his client, Mr. Troyer. Mr. Sheeran may not be able to take that job opportunity on July 5 because he is required and has a sole duty to Mr. Troyer. So his job opportunity may have to be delayed until substitute counsel enters this case and substitute counsel indicates that they will be prepared for that October 31 trial date. So there's no conflict today. And there won't be a conflict as long as Mr. Sheeran does not take that job opportunity.
The court's ordering me to not take a job until a substitution is filed.
No, the court's ordering you to abide by the rules of professional conduct, and you are still the lawyer in this case. If taking a new job opportunity would mean that you would then create a conflict in representing Mr. Troyer, the ethics rules would not permit you to do something like that, absent court permission, and the court has not granted that permission yet.
I understand the court's ruling.
Mr. Hillman, any questions or comments?
No, Your Honor.
Is the state ready to proceed with its motion today?
Yes, Your Honor.
And Mr. Sheehan, are you ready to proceed on behalf of Mr. Troyer?
Yes, Your Honor.
First, before, and I'm going to give counsel plenty of opportunity to address the court on this issue. The court needs to address the issue of jurisdiction of the court. Washington's judicial branch was created in 1889 when the people ratified the Washington Constitution. Article 4 of our state constitution creates Justice of the Peace Courts, which in 1989 were renamed district courts by the legislature, and that was on RCW 3.30.015. A court's jurisdiction is comprised of two components: jurisdiction over the subject matter and jurisdiction over the person. And that is from Buecking versus Buecking, that's Buecking. It's a Supreme Court case 179, Washington 2nd, 438 from 2013. Subject matter jurisdiction refers to a court's lawful ability to hear and determine a type of case. A court order is void where a court lacks subject matter jurisdiction to issue the order. Personal jurisdiction refers to a court's lawful ability to preside over a particular party, and that's also the Buecking case that discusses that. District courts have jurisdiction over all misdemeanors and gross misdemeanors committed by adult offenders in their respective counties. RCW 3.66.060, parenthesis 1. Mr. Troyer is charged with committing two gross misdemeanors. These crimes are alleged to have been committed in Tacoma, which is within Pierce County, Washington. Pierce County District Court has subject matter jurisdiction over this case. Mr. Troyer is an adult. Pierce County District Court has personal jurisdiction over Mr. Troyer. Finally, as I indicated at the beginning, I am a Kitsap County District Court judge. Pursuant to General Rule 29, the Pierce County District Court presiding judge and the Kitsap County District Court presiding judge have approved me to act as visiting judge in this case. Pursuant to RCW 3.34.140, on November 3, 2021, the Kitsap County Board of County Commissioners enacted resolution number 192-2021, which authorizes me to serve as visiting judge in this case. Court concludes that I have authority to preside over this case. Does the state have any comment about the court's jurisdiction?
No, Your Honor.
Mr. Sheeran does a defense.
No, Your Honor.
The state has filed a motion in this matter asking the court to do two things. First, to amend the conditions of release that the courts previously imposed pursuant to CRRLJ 3.2J1. Hereafter, I'll refer to this as just Rule 3.2. And to two, revoke Mr. Troyer's release on personal recognizance and impose bail pursuant to Rule 3.2J2. A little bit of background in this case. Charges in this case were filed on October 19, 2021, and the state alleges that these charges arise out of an incident date that allegedly occurred on January 27, 2021. Two charges have been filed in this matter: false reporting and making a false or misleading statement to a public servant. On December 3, 2021, at the court's first pretrial, and this was my first appearance in this case, and the court found probable cause existed in support of both charges. Under Rule 3.2a, a criminal defendant, is presumed to be released on the person's personal recognizance unless one or two things occur. One, the court determines recognizance will not reasonably assure the accused's appearance in court when required. Or two, the court determines a showing of likely danger that the defendant will A, commit a violent crime, or B, will seek to intimidate witnesses, or C, to otherwise unlawfully interfere with the administration of justice. Rule 3.2a provides that the court shall, on available information, consider the relevant factors, including but not limited to Rule 3.2c, relevant factors for future appearance, and Rule 3.2e, relevant factors concerning a showing of substantial danger. After considering these court rule factors on available information, on December 3, this court ordered Mr. Troyer to be released on his personal recognizance. However, this court did impose some conditions of release, including one, that Mr. Troyer shall have no contact with Cedric Altheimer. Two, that Mr. Troyer shall have no similar incidents. Three, that Mr. Troyer shall maintain law-abiding behavior. Four, that Mr. Troyer shall remain in contact with his defense attorney. And five, that Mr. Troyer shall have no discussions about this case with any witnesses, including law enforcement witnesses. Mr. Troyer did not object to these conditions of release. On March 11, 2022, at the second pretrial conference on this matter, the court imposed the same release conditions. Mr. Troyer did not object to these conditions of release. On May 6, 2022, the third pretrial conference in this matter, the court imposed the same conditions. Mr. Troyer did not object to these conditions of release, and the court set three court dates: July 29, 2022 at 1:30, which is a pretrial conference; October 26, 2022 at 8:45 a.m. for a readiness hearing; and October 31, 2022 at 9 o'clock for the jury trial, and those dates remain in effect at this time. On June 17, 2022, the state filed its motion in this case, which included several attached exhibits from a civil case that was also handled by this court previously. It's the matter of Cedric Dwayne Altheimer versus Edwin C. Troyer, Pierce County District Court number 2A602411A, which is a civil protection order case. Attached to the state's motion in this matter, attachments include Mr. Altheimer's petition for the order of protection, which was filed in the civil matter on May 20, 2022, and the state denominated that as Exhibit D. Also attached to the state's motion is a temporary anti-harassment protection order and notice of hearing, which was filed in this court, in the civil matter in this court, on May 23, 2022. That's denominated as Exhibit E. An affidavit of Edward C. Troyer, which was filed in the civil matter in this court on June 6, 2022, which was denominated by the state as Exhibit F. A verbatim report of proceedings of the June 6, 2022 full hearing that I've discussed in the civil matter, that's Exhibit G. And finally, an order for protection from unlawful civil harassment that this court signed in the civil matter on June 6, 2022, Exhibit H. Does the state wish to submit any other additional evidence in support of its motion?
No, Your Honor.
To the defense, does the defense have any evidence it would like to submit on behalf of concerning the state's motion?
No, Your Honor.
Does the state have any does the defense have any comment concerning the evidence that the state submitted, which is attached to its motion, No, sir. This time I do want to entertain argument from the parties about this, and so we'll start with the state. Mr. Hillman.
Thank you, Your Honor. As you indicated, there's essentially two parts to the state's motion, and the first thing that we're asking for is that the conditions of release be amended or modified to incorporate the civil anti-harassment order that was entered on June 6th. It makes sense to the state that since Mr. Troyer is required by law to follow all of the conditions in that anti-harassment order, that they be incorporated into the conditions of release. In this case, which are, somewhat vague in that it just says no contact, which I understand is normal, but I think it would bring some clarity to what he's allowed and not allowed to do, which is everything that's in the civil anti-harassment order applies to both that case and to this case. And possibly to short circuit this, if I understand correctly, I don't believe that the defense has an objection to this part of the motion.
Mr. Sheeran.
I believe it's rather redundant to both law-abiding behavior and no contact, but but substantively, no objection to the inclusion of that in a amended conditions of release order, Your Honor.
Court's going to review the evidence that has been provided to the court, which is attached, as I've indicated, to the state's motion. First, the petition for protection order, which was filed on May 20, 2021 in the civil matter. It's denominated as Exhibit D. In that matter, in that petition, Mr. Altimer testified under penalty of perjury and alleges Mr. Troyer repeatedly engaged in harassing conduct towards Mr. Altimer. Mr. Troyer's contact was unwanted and was escalating. Mr. Altimer has overwhelming fear he might be imprisoned or lose his life due to Mr. Troyer's alleged conduct. Mr. Altimer is a young black man who knows he will not be given the benefit of the doubt if Mr. Troyer is able to convince law enforcement that Mr. Altimer is a threat to Mr. Altimer. Mr. Altimer also believes that in our society, a young black man is assumed to be dangerous on sight. And Mr. Altimer has a family to support and has a job where he delivers newspapers. In the emergency ex parte temporary protection order, which was granted on May 23, 2022 in the civil matter, Exhibit E, Judge Pro Tem Havens granted Mr. Altimer's motion for an emergency temporary protection order. Mr. Troyer's conduct was restrained by the temporary order, and then the full hearing was set for June 6, 2022. At the full hearing on June 6, 2022 in the civil protection order matter, it was held before Judge Pro Tem Chin, who was presiding over the matter. Mr. Altimer testified by his petition, which I've already discussed. He also testified under penalty of perjury at the hearing itself, and that transcript has been provided to the court, which is Exhibit G and attached to the state's motion. Mr. Altimer testified that on November 2021, February 8, 2022, and at several other times, Mr. Altimer saw Mr. Troyer driving Mr. Troyer's white Chevrolet Tahoe, always when Mr. Altimer was delivering newspapers between 1 and 2 o'clock in the morning during Mr. Altimer's paper route. Mr. Altimer testified that Mr. Troyer just pops up in the vicinity, that Mr. Troyer flashes his vehicle headlights while driving his white Tahoe. Mr. Altimer knows Mr. Troyer's vehicle because Mr. Altimer has memorized the vehicle license plate number, which Mr. Altimer testified to as DWT 0616. Mr. Altimer alleged that Mr. Troyer circled around the block, drove directly past Mr. Altimer. Mr. Altimer believed that Mr. Troyer could see it was Mr. Altimer because Mr. Altimer's driver's side window is down so Mr. Altimer can deliver newspapers, and that Mr. Troyer would drive by Mr. Altimer a few times and be gone. Those are Mr. Altimer's allegations concerning a November 2021 incident, a February 8, 2022 incident, and several other times. Mr. Altimer continued to testify specifically concerning April 13, 2022. Mr. Altimer was on his paper route, that Mr. Troyer followed Mr. Altimer between 12:45 a.m. and 1:05 a.m., that Mr. Troyer, driving his white Tahoe, just popped up and circled around the block. that Mr. Troyer drove in the opposite direction directly by Mr. Altimer several times, and that Mr. Altimer sees that Mr. Troyer was driving the vehicle. Specifically on April 27, 2022, Mr. Altimer testified that he was delivering newspapers on his route, and it was between 1 and 2 o'clock in the morning. Mr. Altimer testified that Mr. Troyer drove his white Tahoe, Mr. Troyer was in his white Tahoe parked by a tree on the sidewalk, that Mr. Troyer was ultimately standing outside his vehicle, that Mr. Altimer stepped out of his vehicle to deliver newspapers during his paper route, and that Mr. Troyer yelled at Mr. Altimer, quote, "That's my dad's house," end of quote. Mr. Altimer was scared and left the area. Mr. Troyer also testified in the civil matter. That's Exhibit F. He testified by declaration, and of course that was under penalty of perjury. Mr. Troyer admitted that he knows this court ordered Mr. Troyer to not have any contact with Mr. Altimer. Mr. Troyer admitted that he is the elected Pierce County Sheriff. Mr. Troyer admitted that he had contact with Mr. Altimer on January 27, 2021, which is the incident date in this criminal case. Mr. Troyer testified that on April 27, 2022, in the early morning, Mr. Troyer was parked outside his father's residence. Mr. Troyer was there to check on his father, an 84-year-old diabetic. Mr. Troyer testified he was inside his vehicle. Mr. Troyer testified he observed a man get out of the vehicle and approach the house. Mr. Troyer testified he did not recognize this man. Mr. Troyer then got out of his vehicle. Mr. Troyer testified that he told this man, quote, "It was my childhood home and my father's residence," end of quote. Mr. Troyer testified he did not realize who the person was until the person identified himself as Mr. Altimer. Mr. Troyer testified that he has had no other contact with Mr. Altimer other than that April 27 date and the original incident date on January 27. Finally, Mr. Troyer testified that he has abided by this court's order prohibiting contact with Mr. Altimer. Judge Pro Tem Chin found that Mr. Altimer met his burden of proof and then granted the full protection order, which will expire on June 6, 2023. Judge Pro Tem Chin restrained Mr. Troyer from making any attempts to contact Mr. Altimer, making any attempts to follow or to keep Mr. Altimer under surveillance, from entering or being within 1,000 feet of Mr. Altimer's residence or his workplace. To enter an unlawful protection order in Washington, the following must be shown. The legislature has found in RCW 9A.46.010, quote, "The legislature finds that the prevention of serious personal harassment is an important government objective." The legislature continues, quote, "Toward that end, this chapter is aimed at making unlawful the repeated invasions of a person's privacy by acts and threats which show a pattern of harassment designed to coerce, intimidate, or humiliate the victim." Under Washington law, this would be former RCW 10.14.020 and .030, a court must find 7 items have been proven, 7 separate statutory elements have been proven by preponderance of the evidence to issue a protection order. Judge Pro Tem Chin found Mr. Altimer's testimony credible and found by preponderance of the evidence that Mr. Altimer proved, 1, this is the judge finding now, that Mr. Altimer proved, 1, Mr. Troyer acted knowingly and willfully. Mr. Troyer engaged in a course of conduct which includes A, a pattern of conduct, and B, a series of acts over a period of time, however short, and C, evidencing a continuity of purpose. The court also had to find, 3, Mr. Troyer's course of conduct A would cause a reasonable person to suffer substantial emotional distress, and B, actually cause substantial emotional distress to Mr. Altimer. 4, it would be required that, and the judge found, that Mr. Troyer's course of conduct was directed at a specific person, Mr. Altimer. The court found that Mr. Troyer's course of conduct seriously alarmed, annoyed, harassed, or is detrimental to Mr. Altimer. 6, the court found that Mr. Troyer's course of conduct served no legitimate or lawful purpose. And finally, 7, the court found that Mr. Troyer's course of conduct was not protected by the Constitution. Rule 3.2J2 provides that a court may revoke release and impose bail upon a showing that the accused has willfully violated a condition of release after holding a hearing, and the court's holding that hearing right now. Rule 3.2J2 also provides that release may be revoked only if the violation is proved by clear and convincing evidence. The court rule does not define clear and convincing evidence. The phrase clear and convincing evidence, or clear, cogent, and convincing evidence, is most often used in the context of civil litigation. WPI 160.1.02, and the WPI is the pattern instructions for civil cases, defines clear, cogent, and convincing proof to mean proof that an occurrence is, quote, highly probable, end of quote. This court adopts WPI 160.02, the highly probable definition of clear and convincing evidence, as that phrase is used by Rule 3.2J2. The issue before the court today then is, has the state proven by clear and convincing evidence, in other words, has the state proven by highly probable evidence that Mr. Troyer willfully violated a condition of release ordered by this court? In making that determination, the matter really comes down to the credibility of witnesses, the credibility of Mr. Altimer versus Mr. Troyer, based upon the record that has been submitted to this court. A trier of fact has guidance concerning how it is to weigh the credibility of conflicting testimony. WPIC 1.02, and this is the criminal jury instruction, tells the trier of fact how to weigh the credibility of witnesses, and it provides, in considering a witness's testimony, a trier of fact may consider these things: the opportunity of the witness to observe or know the things he or she testifies about, the ability of the witness to observe accurately, the quality of the witness's memory while testifying, the manner of the witness while testifying, any personal interest that the witness might have in the outcome or the issues, any bias or prejudice that the witness may have shown, the reasonableness of the witness's statements in the context of all of the other evidence, and any other factors that affect an evaluation or belief of a witness or an evaluation of his or her testimony. The court will review its evaluation of Mr. Altimer's testimony and is relying upon Exhibit D, the petition, and Exhibit G, the transcript of the June 6, 2022 civil hearing. Following the WPIC 1.02 factors, opportunity of Mr. Altimer to observe or know the things he testifies about. Mr. Altimer was at his place of employment during his regular business hours, 1 to 2 o'clock in the morning. On all occasions, he alleges Mr. Troyer had contact with him. Mr. Altimer had the opportunity to observe and know the things he testified about. The ability of Mr. Altimer to observe accurately. Mr. Altimer in his vehicle delivering newspapers in his paper route. He has memorized the license plate of Mr. Troyer's white Chevrolet Tahoe and recognizes both Mr. Troyer's vehicle and recognizes Mr. Troyer in person. On all the dates in his petition and in his court testimony, Mr. Altimer alleges Mr. Troyer drove his white Chevrolet Tahoe when Mr. Troyer was following or had contact with Mr. Altimer. In this court file, the probable cause statement at page 5, it is alleged that on January 27, 2021, Mr. Troyer drove a white Chevrolet Tahoe, which is alleged in the probable cause statement, which is his personal vehicle. Mr. Altimer has the ability to observe accurately. The quality of Mr. Altimer's memory while testifying. Mr. Altimer offered several specific examples of conduct that Mr. Troyer engaged in during Mr. Altimer's delivery of newspapers. Mr. Altimer's quality of memory about these contacts is high. The manner of Mr. Altimer while testifying. This court obviously did not see the testimony, and so that would not be a factor the court would be able to assess. Any personal interest that Mr. Altimer might have in the outcome or the issues. Mr. Altimer certainly wants Mr. Troyer convicted for Mr. Troyer's actions concerning Mr. Altimer on January 27, 2021. Mr. Altimer is also seeking millions of dollars in a civil case arising out of the January 27, 2021 incident with Mr. Troyer. Mr. Altheimer has a personal bias in the outcome or the issues. Any bias or prejudice the witness may have shown. Mr. Altheimer has not shown any bias or prejudice in the evidence that's been presented before this court. The reasonableness of Mr. Altheimer's statements in the context of all of the other evidence. At all times relevant to the state's motion, Mr. Altheimer was at work. Mr. Altheimer's work, delivering newspapers, occurs between 1 and 2 o'clock in the morning. Mr. Altheimer works at a very specific geographic location. Mr. Altheimer has no reason to expect to ever see Mr. Troyer while Mr. Altheimer is delivering newspapers on his route while he is at work at that time of the early morning. This is especially true in light of this court's order prohibiting Mr. Troyer from having any contact with Mr. Altheimer since December 3 of 2021. Any other factors that affect the evaluation or belief of Mr. Altheimer or the evaluation of his testimony. While there are certainly many disagreements between the state and the defense, it is uncontroverted that on January 27, 2021, Mr. Troyer had personal contact with Mr. Altheimer while Mr. Altheimer was delivering newspapers during his route between 1 and 2 o'clock in the morning. Mr. Troyer and Mr. Altheimer did not know each other before January 27, 2021. Mr. Troyer contacted dispatch after communicating with Mr. Altheimer. As a result, a massive law enforcement response arrived at the location. Tens of officers were present, carrying firearms and other law enforcement equipment. Mr. Altheimer was seized by law enforcement, meaning he was not free to leave, was interrogated, searched, and delayed in completing his work as delivering newspapers. Mr. Altheimer is not charged with a crime arising out of the January 27, 2021 incident. Mr. Troyer is charged with 2 gross misdemeanor crimes arising out of the January 27, 2021 incident. Judge Pro Tem Chin entered an anti-harassment protection order based upon Mr. Altheimer's testimony, which that judge found was credible. Mr. Altheimer's testimony is also bolstered by Mr. Troyer's testimony, admitting Mr. Troyer had contact with Mr. Altheimer on April 27, 2022. Mr. Troyer knows where Mr. Altheimer works. Mr. Troyer knows when Mr. Altheimer works, between 1 and 2 o'clock in the morning. Mr. Troyer admitted he was voluntarily in the area on April 27, 2022 in the early morning hours and got out of his vehicle and spoke with Mr. Altheimer. Mr. Altheimer properly sought a civil protection order shortly after the April 27, 2022 incident where Mr. Troyer spoke to Mr. Altheimer while he was at work. Any other conditions concerning, or any other factors concerning Mr. Altheimer's credibility? Race. Mr. Altheimer is a young black man who delivers newspapers to support himself and his family. Mr. Altheimer is not a powerful man. Mr. Troyer is a white man and sheriff of one of the largest law enforcement agencies in Washington. Mr. Troyer is one of the most powerful men in Pierce County, with access to an entire law enforcement agency, firearms, and databases with tremendous ability to seek out, track, and find individuals. The Washington Supreme Court has been clear that Washington's judicial branch will not tolerate racism or bias in Washington's courts. General Rule 37 was amended in 2018 to eliminate the unfair exclusion of potential jurors based on race or ethnicity. On June 9, 2022, the Supreme Court in the case of State versus Sum, S-U-M, held that a trial court should consider race and ethnicity when determining whether a person is lawfully seized by law enforcement. Yesterday, the Washington Supreme Court in State versus Zamora, Z-A-M-O-R-A, held that a prosecutor commits race-based misconduct during jury selection by appealing to ethnic or racial biases and stereotypes. The Washington Supreme Court has directed Washington trial courts to view race and ethnicity from that of an, quote, objective observer, end of quote.
All right, we'll be right back.
It just liberates you just to really go all over the place and try different things in a way that, just as myself, sometimes I find it hard to feel that sense of freedom.
Watch the next Joker. It goes right in between. All I do is through the hand. And it changes.
That is crazy.
Uvalde, Texas, a small town that has become yet another landmark. Back now with our NBC News exclusive.
It's an Anacortes edition of Evening. Explore the gateway to the San Juans by kayak.
All you have to do is go out and have a good attitude and have fun.
And get a taste of what this town has to offer. Evening tonight at 7:30 on King 5.
Are you ready for a fresh new bath or shower? Well, now is the best time with 50% off installation and no interest and no payments for 1 year. Hi, I'm Christina, and it's time to flip your old worn out bath or shower with Jacuzzi Bath Remodel today. Everyone knows the Jacuzzi brand. They're the most trusted name in water for over 60 years. But did you know they can install a gorgeous bath or shower that feels incredible in as little as 1 day? It's no stress and no mess with a lifetime warranty. Now let's talk beauty. You deserve to start and end your day in a beautiful space that feels great and is custom designed just for you.
Next, the court will assess and evaluate Mr. Troyer's testimony under WPIC 1.02 and the factors listed there. But first, the Fifth Amendment to the United States Constitution provides that no person can be compelled in any case to be a witness against themselves. This right to remain silent, as discussed by the United States Supreme Court in Miranda versus Arizona 1966 case, applies to Mr. Troyer because he is charged with committing a criminal offense and his case is pending trial. A person's exercise of the Fifth Amendment right to remain silent cannot be used against them as evidence of guilt. However, if a person accused of a crime chooses to testify, the person's testimony and the person's credibility are examined in the same manner as other witnesses. Mr. Troyer chose to testify voluntarily in the Civil Protection Order case. Focusing on the WPIC 1.02 factors concerning Mr. Troyer's testimony. Mr. Troyer denies all contact with Mr. Altheimer except on April 27 and April 27, 2022 and January 27, 2021. Accordingly, the court will focus on the April 27, 2022 incident and Mr. Troyer's testimony concerning that incident. The opportunity of Mr. Troyer to observe or know the things he testifies about. On April 27, 2022, Mr. Troyer was at Mr. Altheimer's location of employment during Mr. Altheimer's regular business hours between 1 and 2 o'clock in the morning, when Mr. Troyer had contact with Mr. Altheimer. Mr. Troyer had the opportunity to observe and know the things he testified about. The ability of Mr. Troyer to observe accurately. Mr. Troyer was outside his parked vehicle when he spoke with Mr. Altheimer. Mr. Troyer had the ability to observe accurately. The quality of Mr. Troyer's memory while testifying. Mr. Troyer testified. He specifically said, quote, "It was my childhood home and my father's residence," to a person who was Mr. Altheimer. Mr. Troyer's quality of memory about this contact is high. Manner of Mr. Troyer's testimony the manner of Mr. Troyer while he was testifying. Mr. Troyer testified by affidavit, so the court's not able to assess that factor. Personal interest Mr. Troyer might have in the outcome or the issues. Mr. Troyer is charged with 2 gross misdemeanors in this case. Each charge carries a maximum penalty of 364 days in jail upon conviction. If convicted of both charges, Mr. Troyer could be sentenced to up to 728 days in jail. If convicted, Mr. Troyer's career as a law enforcement officer may cease. If convicted, Mr. Troyer would follow in the legacy of former Pierce County Sheriff George Janovich, who over 40 years ago was convicted of crimes he committed while in office. Mr. Troyer has a personal interest in the outcome or the issues. Any bias or prejudice the witness may have shown. The probable cause statement alleges Mr. Altheimer was driving a 1995 Geo Prism on January 27, 2021, around 2 o'clock in the morning delivering newspapers when Mr. Troyer followed and had contact with Mr. Altheimer. Without any evidence or knowing, at least that's in the record, or knowing Mr. Altimer was a young black man, Mr. Troyer accused Mr. Altimer of being, quote, a porch pirate, end of quote, and Mr. Troyer told dispatch that Mr. Altimer was possibly homeless. Mr. Troyer's statements and actions on January 27, 2021 exhibit a bias or prejudice belief that a young black man driving an old vehicle around 2 o'clock in the morning in a residential area must be homeless and likely to be engaged in criminal activity. The reasonableness of Mr. Troyer's statements in the context of all the other evidence. Mr. Troyer testified he was at the location on April 27, 2022 to check on his father, an 84-year-old diabetic. On April 27, 2022, of all the places in the world Mr. Troyer chose to be, he chose to be at 1 o'clock in the morning, between 1 and 2 o'clock in the morning, at a location where Mr. Altimer would likely be working. It is not reasonable for Mr. Troyer to choose to check on his father's welfare at 1 to 2 o'clock in the morning at a location Mr. Altimer would likely be working, given the court's order prohibiting Mr. Troyer from having any contact whatsoever with Mr. Altimer. Additionally, Mr. Troyer was not inside his father's house at 1 to 2 o'clock in the morning, checking on his father when he had contact with Mr. Altimer. Rather, Mr. Troyer was inside his vehicle parked on the street when he saw a man drive up, exit the vehicle, and walk towards Mr. Troyer's father's house. Mr. Troyer was sitting in his parked vehicle when Mr. Altimer approached. If Mr. Troyer was checking on his father, he would have gone inside the father's house, checked on him, and left the area. It is not reasonable for Mr. Troyer to check on his father by sitting in his vehicle where it was located at 1 to 2 o'clock in the morning on April 27, 2022. Mr. Troyer testified he did not recognize this man. Mr. Troyer knows who Mr. Altimer is. It is not reasonable to believe Mr. Troyer did not know the person approaching was Mr. Altimer, especially given the location, time of the morning, and knowledge Mr. Altimer would likely be working delivering newspapers in the area. Mr. Troyer chose to exit his vehicle to speak with this man who happened to be walking near Mr. Troyer's father's house. Speaking with this person had nothing to do with Mr. Troyer checking with his father, or on his father. Mr. Troyer chose to speak with this person and say, quote, "It was my childhood home and my father's residence." Speaking with this person had nothing to do with Mr. Troyer's alleged purpose of checking on his father. It is not reasonable to believe Mr. Troyer would exit his vehicle to tell an unknown stranger at 1 to 2 o'clock in the morning where Mr. Troyer grew up or where Mr. Troyer's father resided. Mr. Troyer knew the person he was approaching was Mr. Altimer when he exited the vehicle and approached Mr. Altimer. Mr. Troyer testified he did not realize this person to be Mr. Altimer until Mr. Altimer identified himself to Mr. Troyer. It is not reasonable to believe Mr. Troyer would not recognize Mr. Altimer by sight. Mr. Altimer is a key material witness in this criminal prosecution. Mr. Troyer's testimony that his contact with Mr. Altimer on April 27, 2022 was solely by happenstance, a coincidence, or unexpected. Happenstance would be Mr. Troyer walking into a grocery store in the afternoon and seeing Mr. Altimer shopping. Happenstance is not at 1 to 2 o'clock in the morning where Mr. Altimer works delivering newspapers. Mr. Troyer's testimony is not reasonable. Mr. Troyer's testimony that he was there to check on his father is false or misleading. The only reason Mr. Altimer would be sitting in his vehicle at that location at 1 to 2 o'clock in the morning on April 27, 2022 was to seek to contact Mr. Altimer while Mr. Altimer was at work. Mr. Troyer's testimony that he got out of his vehicle at 1 to 2 o'clock in the morning to tell an unknown person and complete stranger that he grew up in the house, that the house was his childhood home and his father's residence makes absolutely no sense. The testimony is false or misleading. Mr. Troyer's testimony that he did not know the person was Mr. Altimer until Mr. Altimer identified himself after Mr. Troyer spoke is unreasonable and patently false. Mr. Troyer knew where and when Mr. Altimer worked delivering newspapers. Mr. Troyer knew full well it was Mr. Altimer when Mr. Troyer approached and spoke with Mr. Altimer on April 27, 2022. It is reasonable to conclude that Mr. Troyer was waiting at that location at that time to contact Mr. Altimer. Any other factors that affect the evaluation or belief of Mr. Troyer or the evaluation of his testimony. Due to the January 27, 2021 incident with Mr. Troyer knows where Mr. Altheimer works. Mr. Troyer knows when Mr. Altheimer works. Mr. Troyer knows Mr. Altheimer delivers newspapers between 1 and 2 o'clock in the morning in a specific geographic location. Mr. Troyer knows that in deciding to release him on his personal recognizance, this court ordered Mr. Troyer on 3 separate occasions to have no contact with Mr. Altheimer. Mr. Troyer also knows that in deciding to release Mr. Troyer on his personal recognizance, this court ordered Mr. Troyer on 3 separate occasions to have no similar incidents with Mr. Altheimer. Mr. Troyer knows that due to these court orders, Mr. Altheimer would have no reason to expect to ever see Mr. Troyer while Mr. Altheimer is delivering newspapers on his route while at work between 1 and 2 o'clock in the morning. While there are many disagreements between the state and the defense in this case, it is uncontroverted that Mr. Troyer had personal contact with Mr. Altheimer while Mr. Altheimer was delivering newspapers between 1 and 2 o'clock in the morning on January 27, 2021, the incident date. Mr. Troyer and Mr. Altheimer did not know each other until January 27, 2021. Mr. Troyer contacted dispatch after communicating with Mr. Altheimer on January 27, 2021. As a result, a massive law enforcement response arrived at the location. Tens of officers were present, all carrying firearms and other law enforcement equipment. Mr. Altheimer was seized by law enforcement, meaning he was not free to leave. He was interrogated, searched, and delayed in completing his work delivering newspapers. Mr. Altheimer has not been charged with a crime arising out of the January 27, 2021 incident. Mr. Troyer has been charged with 2 gross misdemeanor crimes arising out of the January 27, 2021 incident. Judge Pro Tem Chin entered an anti-harassment order based upon Mr. Altheimer's testimony, which the judge found credible. Mr. Altheimer's testimony is bolstered by Mr. Troyer's testimony that Mr. Troyer was voluntarily in the area on April 27, 2021, got out of his vehicle and spoke with Mr. Altheimer. Any other factors concerning Mr. Troyer's credibility? Race. Mr. Troyer knows Mr. Altheimer is a young black man who delivers newspapers to support himself and his family. Mr. Troyer knows Mr. Altheimer is not a powerful man. Mr. Troyer is a white man and sheriff of one of the largest law enforcement agencies in Washington. Mr. Troyer is one of the most powerful men in Pierce County with access to an entire law enforcement agency, firearms, and databases with tremendous ability to seek out and track individuals. Any objective observer would conclude that a young black man in Mr. Altheimer's place would reasonably suffer substantial emotional distress and be scared to death of any contact with Mr. Troyer, the sheriff, after the incident of January 27, 2021. Mr. Troyer would know that about Mr. Altheimer, as well as when he allegedly had contact with Mr. Altheimer on April 27, 2022. Based on the record before this court, and weighing the credibility factors just discussed concerning Mr. Altheimer's testimony and Mr. Troyer's testimony, the court finds that Mr. Altheimer's testimony is credible and truthful, and the court finds that Mr. Troyer's testimony is not credible and finds portion of his testimony to be false or misleading. Clear and convincing evidence. Based upon the evidence presented in this case, the court grants the state's motion to amend Mr. Troyer's conditions of release and to revoke Mr. Troyer's release on personal recognizance because the state has proven under Rule 3.2J1 that there has been a change of circumstances, has proven new information, and has proven a showing of good cause to amend the court's order of release to impose additional conditions of release on Mr. Troyer. The state has also proven and shown by clear and convincing evidence under Rule 3.2J2, in other words, the state has proven it is highly probable that Mr. Troyer has on multiple occasions willfully violated this court's thrice ordered conditions to protect Mr. Altheimer by 1, Mr. Troyer has on multiple occasions willfully violated the court's condition of release that Mr. Troyer have no contact with Mr. Altheimer. 2, Mr. Altheimer has on multiple occasions willfully violated the court's condition of release that Mr. Altheimer not have other similar incidents as alleged to have occurred on January 27, 2021 by subsequently following Mr. Altheimer while Mr. Altheimer was at work delivering newspapers between 1 and 2 o'clock in the morning. And 3, Mr. Troyer has willfully violated the court's condition of release that Mr. Troyer engage in law-abiding behavior, where Mr. Troyer was found by this court in a civil proceeding on June 6, 2022, to have violated Washington law by unlawfully harassing Mr. Altimer, resulting in entry of a 1-year protection order to protect Mr. Altimer from harassing behavior by Mr. Troyer. Rule 3.2D authorizes a court to impose conditions of release, including requiring detention and the posting of bail, upon a showing of substantial danger. The first issue to address is, has the state shown under Rule 3.2D that there exists a substantial danger that 1, Mr. Troyer will commit a violent crime, or 2, Mr. Troyer will seek to intimidate witnesses, or 3, Mr. Troyer will unlawfully interfere with the administration of justice. The second issue is, if the state has shown substantial danger, what, if any, Rule 3.2D conditions should the court impose? Mr. Hillman, the court would like to hear your thoughts on these two topics on 3.2D.
Sorry, Your Honor, you're asking which of those?
Well, what conditions of release, if any, you're asking for in light of the court's findings today?
Well, Your Honor, that the state's asking that the court condition Mr. Troyer's ongoing release on the posting of $10,000 bail, and that the court incorporate the anti-harassment order from the civil protection proceeding, which includes certain restrictions as to the distance that Mr. Troyer can be from Mr. Altimer's vehicle, his residence, and his workplace. Obviously, continue the prohibition against any violations of the criminal law. Any other factors that the court deems appropriate. I did want to say one thing. When I began my argument, there were two parts, which is, incorporating the protection order and then the willful violation of the conditions of release and revocation of release. And I mentioned that we could short circuit that by, because the defense was not objecting to incorporation of the protection order. And then I was going to present argument and outline all of the evidence and why there was a willful violation. And I think the court has very thoroughly considered all of the evidence that's been presented and identified the very same evidentiary pieces of evidence that show a willful violation. But my one concern before the court, if my memory is correct, before the court issues a final ruling, is that the defense have an opportunity to be heard on that. If I'm remembering things right, and if there was confusion and that was my fault, I apologize. But I did intend it to be a two-part argument, and we discussed the incorporation of the anti-harassment order. But I just want to make sure, and maybe there's nothing to be said, but that the defense has an opportunity to be heard about the willful violation of the protection order.
Well, the court certainly wants to hear from the defense.
Yeah.
Mr. Hillman, is there anything else you want to present before I switch over to Mr. Sharon?
No, Your Honor. I think the court has very thoroughly reviewed the evidence that the state has presented. It's uncontested, it's uncontroverted, and the state would ask the court to find the willful violation, revoke release, and condition release pending the October 31st trial on the posting of $10,000 bail.
Mr. Sharon.
Mr. Hillman's correct. What I believe he and I were stipulating to was simply the inclusion of the anti-harassment order in the court's new conditions of release. The court may have misread that a little bit. But the court's made clear where the court stands. So I'm not going to go back and try to argue with Your Honor why I believe you're wrong on several fronts. Insulting on several fronts.
You're certainly entitled to say what you want to say, Mr. Sheeran.
Not gonna waste Your Honor's time. Your Honor's made a decision. Question is the court going to impose bail when $10,000 bail, $1,000 to a bonding company is just a penalty? This has nothing to do with conditions of release. It's not a question of is somebody going to or not going to interfere with the administration of justice or intimidate witnesses. It's a penalty. And that's what this was about. This was about that from the beginning. There is no expectation that a $10,000 bail was anything other than that. If the court wishes to impose it, so be it. I don't think it serves the ends of justice. I don't think it serves the purpose of the rule. But it'll be posted. And we'll be back here for trial.
Respond briefly, Your Honor. I disagree. You know, there's a presumption of release on personal recognizance based on the defendant's promise that he'll abide by the conditions of release. But if he's not going to do that, then we set bail to further encourage him to do so, because if he fails to do so, not only is he violating the conditions of release and potentially going into custody, but he's going to lose $10,000. And that's what the state's asking the court here to do, is to send a message to the defendant that intimidation of witnesses pending trial is not going to be tolerated by the court. If you want to be released on personal recognizance and you can't follow the court's order, then we're going to set bail. And then if you violate those conditions of release again, there's going to be additional conditions of release that might be more severe, and you're going to lose $10,000. And that's what the state's asking the court to do. It's an administration of justice issue, and it's appropriate.
Mr. Sheeran.
Nothing.
The court finds that by committing these violations of court conditions of release, Mr. Troyer intentionally sought to intimidate Mr. Altimer, a key material state witness, from cooperating and or testifying in this case. The court also finds that Mr. Troyer's decision to submit a false or misleading testimony to the court in the civil protection order case was an unlawful attempt to convince the court to deny Mr. Altimer's petition for a protection order. The court finds that Mr. Troyer's submission of false or misleading testimony in an effort to avoid entry of a protection order unlawfully interferes with the administration of justice as contemplated by Rule 3.2 in this case. Finally, the court finds that Mr. Troyer's violation of this court's orders imposing conditions of release intended to protect Mr. Altimer is an egregious and potentially dangerous violation. The state has shown under Rule 3.2A2 and 3.2D that there exists a substantial danger that 1, Mr. Troyer will seek to intimidate witnesses, and 2, Mr. Troyer will otherwise interfere with the administration of justice. Rule 3.2D, as we've indicated, provides for a presumption of release on personal recognizance pending trial for a person charged with committing a criminal offense unless the court finds a showing has been made a substantial danger to the community. The court has determined under Rule 3.2A2 and 3.2D that a showing has been made that Mr. Troyer is a substantial danger to the community, especially Mr. Altimer. Rule 3.2D authorizes the court to impose one or more conditions of release where a showing of substantial danger has been made. Rule 3.2D authorizes a court to impose bail or bond only if no restrictive conditions or combination of conditions under the rule would reasonably assure the safety of the community. In the case of State v. Huckins, 5 Washington Appellate 2nd 457, paragraphs 30 to 33, a 2018 appellate court case, the appellate court told the court, a trial court, that it shall sua sponte review Rule 3.2D conditions of release upon determining that a defendant is a substantial danger under the rule. At this point, if the parties want to do so, the court would like to have them focus on the Rule 3.2D conditions of release that the court shouldn't, or shouldn't consider in this matter. And I think there are 7 or 8 of them to consider. So, Mr. Hillman, your thoughts under the conditions under that rule once a substantial showing of danger has been made?
Thank you, Your Honor. Well, certainly, number 1, prohibit the accused from approaching or communicating in any manner with particular persons or classes of persons, in this case, Mr. Altimer. Number 2, prohibit the accused from going to certain geographical areas. I would ask that the court impose the same, I don't know that they're geographical restrictions, but the same restrictions in the anti-harassment order that prohibit Mr. Troyer from coming in with that, I believe it's 1,000 feet of Mr. Altimer's person, residence, vehicle, place of work. I've been away for too long, Your Honor. I did used to be a deputy prosecutor here, but I don't know if Pierce County District Court has pretrial probation services. I don't know that they do. If those are available, I would suggest those. Obviously, number 5, prohibit the accused from committing any violations of criminal law. That was a previously existing condition that the state would ask the court to continue. And then number 6, require the accused to post a secure bond or deposit cash. Again, the state's asking that the court order $10,000 cash or bond. And the state's not asking for any additional conditions.
Mr. Sheeran.
I think I've made my point clear with regard to the bond. The court can do what the court's going to do. I think including probation is largely a waste of time for probation, as much as it is for anybody. I don't know what the state's suggesting, that Sheriff Troyer check in once a week, call once a week. This isn't a case where we would be looking at somebody who would be maybe DUI, where you'd want them to check in to make sure that they were, had their ignition interlock set up or something like that. So I think that, obviously, with respect to the other conditions, I think we've already agreed to that, with anything that's connected to the anti-harassment order. I think the idea of a bond is largely symbolic, but I'll leave that at the court.
Mr. Hillman, anything else?
No, Your Honor, other than there are some counties that have pretrial services pending trial. I don't know that Pierce County is one of them. As the state's representative, we are from the Attorney General's office. We should know those things, but I'm not familiar with what Pierce County has available, and that's all I was suggesting, is if they did have a program like that in place.
Rule 3.2, I'm sorry, Mr. Sheeran, anything else?
No, Your Honor.
Rule 3.2D1, as the parties have discussed these, does authorize the court to prohibit contact. The court did that before, was ineffective. Prohibit the accused from, D2, Rule 3.2D2, prohibit the accused from going to a certain geographical area or premises. I do see in the civil protection order that the court ordered Mr. Troyer not to be within I think it was 1,000 feet of Mr. Altimer's workplace, but that's somewhat undefined in the sense of where that could or could not be. But that's what the court's already ordered, so that has really been discussed by the civil court. 3.2D3, quote, to prohibit the accused from possessing any dangerous weapons or firearms, or engaging in certain described activities, or possessing or consuming any intoxicating liquor or drugs not prescribed to the accused. This case, no issues have been raised with respect to alcohol or drugs, so that prohibition would not make sense. Firearms. On May 23, 2022, the court in the civil protection order case issued a temporary order, and Judge Pro Tem Havens reviewed the requirements of RCW 9.41.800 and determined that there was insufficient evidence to support the issuance of an order requiring Mr. Troyer to surrender any weapons, including firearms that he had, or to issue an order prohibiting Mr. Troyer from owning, possessing, or controlling any weapons, including firearms. Unlike in that civil context, there's much more information available in this criminal case that was not available in that civil case. In this case, Mr. Troyer was ordered to have no contact with Mr. Altimer, period. He was ordered to have no similar incidents. In this case, the court's already found that Mr. Troyer's actions toward Mr. Altimer were an effort to intimidate Mr. Altimer from cooperating and or testifying in this case, at least based on the record that's been presented to the court. And the court has found that Mr. Troyer unlawfully interfered with the administration of justice. The question for the court, this court, because of the charges that have been filed, this court does not have the authority to issue a separate no contact order. If it had the authority to do that, that would require then the court to review the weapons or firearms prohibition. I suppose theoretically, there is a statute in Washington that lists several categories and types of crimes that if are alleged are crimes of harassment that would authorize a court to issue a pretrial harassment no contact order. Even if the court were to consider these crimes to be crimes of harassment, I'd want to have some discussion from counsel and briefing about whether that's even true under that statute. So the court's not going to issue a separate no contact order, but certainly can issue conditions of release. Concerns of the court concerning weapons and firearms. The court has great concerns about Mr. Altimer's safety given Mr. Troyer's recent conduct and Mr. Troyer's position as sheriff. Mr. Troyer as sheriff, has access to firearms and a large law enforcement agency at his disposal. The potential danger to Mr. Altimer, given Mr. Troyer's recent unlawful harassing conduct, plus his access to firearms, cannot be understated in this matter. Mr. Troyer has much to lose if he's convicted. He greatly benefits by attempting to intimidate Mr. Altimer. Violence by the head of a law enforcement agency has occurred in Pierce County in the past. It's not an academic discussion. Pierce County has history of heads of law enforcement agencies involved in dangerous and lethal activity. As I indicated earlier, 4 decades ago, Sheriff George Janovich was convicted of crimes he committed while in office, while sheriff involving threats, intimidation, racketeering, and obstructing. Almost 2 decades ago, Tacoma Police Chief David Brame, after court proceedings were commenced, and while he was chief, shot and murdered his wife and then killed himself. Mr. Troyer's decision to repeatedly violate this court's conditions of release and to unlawfully harass Mr. Altimer present what the court sees as a high potential for lethality. Mr. Altimer may not be safe given the record presented in this court. So, if the court prohibits Mr. Troyer from possessing any dangerous weapons or firearms, what is the impact? And Mr. Sharon, I would want to hear from you on that.
Given the nature of the charges, and I think the court kind of referred to this, I'm not sure the court has the authority under the general, we're talking about false statements, not domestic violence, not crimes of harassment, not crimes against persons. Do I know the impacts on Sheriff Troyer's ability to do his job? He's sworn law enforcement officer in the county. He's required to carry firearms except into the courtrooms. So I can't tell you what the impact would be. I don't think it is necessary nor appropriate. But I do not know the answer to the court's question.
Would you like a recess to have a chance to speak with your client about this topic?
Sure.
And to the reference, I'm referencing, the court's referencing Rule 3.2D, which is in effect once the court finds that there's been a showing of substantial danger. So I don't know if that rule focuses on the type of charge that's been filed per se, but it does make sense for you to have an opportunity to discuss with Mr. Troyer. Plus, it's time for a court break anyway. So at this time, the court will be at recess until 3:10 p.m. 3:10 p.m. Court's at recess.
All right.
Troyer, maybe this is better for Mr. Sharon, but if Mr. Troyer would not be able to, if this court orders him not to possess any firearms, would or could that put his personal and or family safety at risk?
I'm sure it certainly could.
Mr. Sharon?
I think the court's correct, that it would put his family and safety at risk. There are protests pretty regularly. I won't say regularly. There's been more than one outside his house where threats have been directed towards him. So yeah, I would suspect that as we get closer to trial, tempers would be more elevated, that somebody could do something stupid. And it's not like the community doesn't know where he lives. It is a problem for him. So yes, that would be an additional issue. With respect to counsel's reference, I believe it's RCW 43-101-105-2E. And I think there's some debate as to whether or not this court's order could cause a certification issue. But that's, like I say, that would require a hearing months or years from now before we ever got to a decertification issue.
The parties recognize this, and so do I, that under 3.2D, the court has the ability to impose various enumerated and non-enumerated conditions of release after a court finds a safety issue. However, I appreciate the attorney's input on this matter. I most certainly, if the Pierce County Prosecutor's Office would want to be heard on a topic like this, that would be something the court would respect, and courts make better decisions when they have more information rather than less information. The court also has some concerns about Mr. Troyer and his personal safety and his family's personal safety, and so the court is not going to order prohibit Mr. Troyer to have or not have weapons. The law is there; he's expected to follow the law, but the court's not going to entertain that particular item as a condition of release while this case is pending, at least without further information that I don't have at this point. Thank you for your information on that. Rule 3.2D3 continues and also authorizes the court to prohibit Mr. Troyer from engaging in certain described activities upon a showing of substantial danger. This may well relate to our prior discussion, and I want to hear from counsel about this, but if an officer, it wouldn't matter what agency, was charged with crimes arising out of contact with a black man who was simply doing his job, and if the officer was thereafter found to have unlawfully harassed that person in violation of court orders and Washington statutes, and the officer was thereafter found by that conduct to intimidate that witness, the court has little doubt that the head of that law enforcement agency would likely place that officer on administrative leave, potentially take the officer's badge and or gun and commence an investigation. So the benefit of administrative leave is it severely restricts that hypothetical officer's access to a law enforcement database, certainly prohibits the officer from engaging in law enforcement activities while the investigation is going on that would be ordered by the head of that law enforcement agency. So the question is, does Rule 3.2D3, allowing the court to prohibit certain activities, is that broad enough under our state constitution to allow the judicial branch to place Mr. Troyer on administrative leave while this case is pending? Mr. Hillman?
Well, Your Honor, I think, and I know you acknowledge this, we're getting into separation of powers issues with, the executive and the elected sheriff of Pierce County and the judiciary imposing potentially conditions on that position. I guess I would want to know a little bit more about what activities described activities we're considering, or Your Honor is considering restricting or prohibiting. You mentioned, searching criminal databases, I think was one. And I know I'm not the one who's supposed to be asking questions of Your Honor, but if you could give me a little more information.
When the executive branch, of which law enforcement is a member, and the head of that agency chooses to place someone on administrative leave, that's generally the decision of the head of the agency to make that decision. And my understanding is the law and the Constitution would authorize the head of that agency to do that as an employee matter. Mr. Troyer is not an employee of anybody. He's the elected sheriff. And so the question becomes, does this rule allow a court who's a member of a completely different branch of government to do what a head of a law enforcement agency could do if it were an employee that we were talking about?
And you did say all of that, Your Honor. I have obviously not researched that coming into court today, but my suspicion is no, that there's a separation of powers issue. There's certainly, the voters of Pierce County could recall the sheriff if they wanted to. I think there may even be a procedure for impeachment, maybe by the legislature. I can't remember the details of that, but with the caveat that I have not researched it, my gut tells me no.
Mr. Sharon, any thoughts you have on this topic?
Your Honor's already identified the problem and the states agree. No. I mean, think about the political weaponry that could be used and how maybe a judge doesn't like a state legislator. Maybe a judge doesn't like somebody who has some other position in the executive office. Maybe somebody's gotten into a budget fight and all of a sudden he comes in front of them on a DUI. No. For the courts to have the authority to then put particular heads of other branches of the government on quote-unquote administrative leave is not something that the rule contemplates. And absent the rule or case law supporting such a broad reading, I don't think the court has the authority to do that.
Concerning that topic, given a lack of briefing, the court is not going to consider that as a Rule 3.2 D3 described activities that the rule would authorize the court to order. Rule 3.2 D4 discusses the regular report, and counsel talked a little bit about that. Pierce County District Court has limited circumstances where they have ordered pretrial, and that's pretrial. Defendants regularly report when there's something to monitor, and I think it was Sharon that talked about this, if it were a DUI, maybe compliance with the ignition interlock or something, but this case doesn't involve any of that, so, and I don't think the parties are asking the court to, or certainly the state's not asking the court to impose regular reporting, and so the court's not going to consider that as an option in this case. Rule 3.2 D5, prohibit the accused from committing any violations of criminal law. The court has already done that and will continue to require that. Rule 3.2 D6, post a bond, we'll talk about that in a bit. Rule 3.2 D7, place the accused in the custody of a designated person or organization agreeing to supervise the accused. That is really broad language, and I really haven't heard anything in this case that someone would come forward to have that type of activity occur, but I think it's probably fair to at least have the attorneys, if they want to address that topic, if someone like that may exist of a designated person. And so I think I'll start with you, Mr. Sharon, if this is Rule 3.2 D7.
I think it's difficult for me to address it without the idea of who. I mean, I'm presuming the court has no intention of having somebody become the designee. I mean, obviously, if
not unless they're willing to do so. No.
And I don't know anybody that's running to sign up to get involved in this.
Mr. Hillman, any other thoughts you'd like to add?
No, Your Honor.
The court's not going to impose that. 3.2D8, place restrictions on travel, association, or place of abode. Mr. Hillman talked a little bit about that in the civil protection order case. There is a prohibition or a requirement that Mr. Troyer not be within 1,000 feet of Mr. Alzheimer's place of employment. It's a little vague, which causes a court concern because there could be places Mr. Troyer would go that he should be entitled to go to that Mr. Alzheimer might inadvertently be there, but that is not a willful or intentional violation, and that's why I gave the grocery store analogy a little while ago, that if that were a grocery store situation where you do have a happenstance circumstance, I wouldn't consider that to be within that 1,000 feet prohibition if Mr. Troyer had no reason to know at that particular time that Mr. Alzheimer would be around. But Mr. Hillman, your thoughts about the 1,000 feet from the workplace prohibition of the civil court order?
Your Honor, as you know from the transcript, there was some discussion about that between the parties in the civil anti-harassment proceeding and the court. And they've batted around 500,000, 1,500 feet. And I believe the judge mentioned that 1,000 feet was about 2 city blocks, and that's what she wanted Mr. Troyer to stay that distance away from Mr. Alzheimer when he was working his paper out. But I think she also said that, obviously if Mr. Troyer's in his house and Mr. Alzheimer goes by while working, that would not be a violation. But I think that was a reasonable compromise that she reached, and the state would ask the court to, as we've said before, to adopt the entirety of the anti-harassment order, incorporate it into the conditions of release in this case.
And the court agrees with Judge Pro Tem Chin on that. Mr. Troyer, he's not prohibited from being in his residence. He has to come and go from the residence. And so if Mr. Alzheimer had to drive by, I recognize that 1,000-foot may or may not be the route or the workplace that Mr. Alzheimer was involved with, but that would not be a violation. And that's why I wanted, it looks like that was discussed earlier, and I wanted to also make that clear to Mr. Troyer that is not a violation. Mr. Sharon, anything you want to say?
Nothing to add on that, Your Honor. Thank you.
Rule 3.2D9, require the accused to return to custody during specified hours or to be placed on electronic monitoring if available. I'm not aware in Pierce County that there is any type of work release or some type of option where someone would turn themselves back into custody at some point in time on various hours, but I'm not a Pierce County judge normally. So, Mr. Hillman, do you have any information about that? Work release may not be the right phrase because the rule doesn't specifically say that, but that looks like that's what it's contemplating.
I believe you're correct, Your Honor. And my memory from being a prosecutor here some time ago and from prosecuting cases as an assistant attorney general in Pierce County is that they do not have work release. Although that was, it's been several years since I've had to look with that. I hate to say it, but Mr. Troyer probably knows since he runs the jail. But I don't believe that that's an option.
The court will consider that. The second part of that rule talks about electronic home monitoring, and the court is aware in Pierce County District Court that the court has at times authorized pretrial private electronic home monitoring in lieu of bail. The Pierce County District Court does not have its own electronic home monitoring program. Some courts do, this court does not. But it has at times authorized that in lieu of bail or jail. So, Mr. Hillman, your thoughts about electronic home monitoring as a condition of release?
Your Honor, at this time, the state's going to stick with its request that the defendant be detained unless he posts $10,000 bail. If we have a future circumstances like this, hopefully not, as the trial approaches, we'll reconsider that option.
Mr. Sharon?
I think it'd be problematic. I mean, I appreciate the state's position. I think it'd also be problematic given the way electronic home monitoring works is that you get to go to your job. And when your job is the elected sheriff and it's 24/7, it'd be a little bit impossible to comply given a unfortunately, a lot of the violent crime in this county happens after dark.
The court is open to the concept of electronic home monitoring with GPS monitoring in lieu of bail in this case, but I recognize right now that I've not heard anything from the parties that would have the court be comfortable with just ordering it sua sponte without something being put forward that the court could then examine and say, is this a viable option or not? So the court wanted to be imposing electronic home monitoring. Anything else, Mr. Hellman, on behalf of the state, you would like to say concerning the amended conditions of release that the court may impose?
No, Your Honor, other than, if you do choose to incorporate the anti-harassment order, just that we make sure that the clerk makes sure, or I also have a proposed order, that the name and cause number of that order is identified in the conditions of release for this case.
Mr. Sheeran, anything else on any of the potential amended conditions of release the court may impose?
No, Your Honor, thank you.
Pursuant to Rule 3.2J1 and 3.2D, the court amends and imposes the following conditions of release in this case. Mr. Troyer shall not make any attempts to contact Mr. Altimer. Mr. Troyer shall not make any attempts to follow or keep Mr. Altimer under surveillance. Surveillance includes A, making any attempt to keep Mr. Altimer or his workplace or home under surveillance. B, photographing, video recording, or audio recording Mr. Altimer. C, photographing, video recording, or audio recording persons entering or leaving Mr. Altimer's residence. D, accessing any computer or other database concerning Mr. Altimer. E, following Mr. Altimer. F, flashing headlights at Mr. Altimer. And/or G, any other conduct or action by Mr. Troyer or a third party involving keeping a close watch over Mr. Altimer or Mr. Altimer's family. Mr. Troyer shall not enter or be within 1,000 feet of Mr. Altimer's workplace. Mr. Troyer shall not enter or be within 1,000 feet of Mr. Altimer's residence. And I understand that the state requests that the court just incorporate the findings from the civil matter and I cite that cause number. The court's experience has been that can be sometimes confusing to everyone as to what that really means. And when does civil courts order what they ordered, that is the law, but that's the reason why I'm not going to cite these are similar conditions that the court ordered in the civil matter, but I'm just going to spell them out in this court order so that it's understood specifically what this court is choosing to enter as conditions or many conditions of release. Additionally, Mr. Troyer shall maintain law-abiding behavior. Mr. Troyer shall not engage in similar incidents. Mr. Troyer shall remain in contact with his defense attorney. And finally, Mr. Troyer shall not engage in any discussions about this case with any witnesses, including law enforcement witnesses. Mr. Hillman, is there anything else that you would like to be heard additionally on the amended conditions of release of court's order?
No, Your Honor.
Mr. Sharon, anything else on the conditions?
No, sir.
I do want to address a couple of the requests that the state had requested in their pleadings in this matter. And the court's going to deny the state's request to impose a requirement that Mr. Troyer strictly comply with the conditions of release or the civil protection order. Mr. Troyer, like every criminal defendant, is expected to comply with court orders and the law. The court does not want to get involved in a future hearing where the issue becomes whether Mr. Troyer partially complied, mostly complied, strictly complied, or while acting in good faith, unintentionally violated a court order or the law. And so for that reason, the court's not going to use that strictly comply language. The state also asked the court to consider admonishing Mr. Troyer that anything short of strict compliance with orders in the criminal case in the future will result in Mr. Troyer being held in custody until trial. The court denies that request. Realistically, Mr. Troyer either complies with court orders and the law or he does not. If he does not, upon a motion, the court will conduct a hearing like we've done today. And so, of course, not going to admonish Mr. Troyer as requested. Finally, Rule 3.2D6 states, the court may require the accused to post a secured or unsecured bond or deposit cash in lieu of thereof, conditioned on compliance with all conditions of release. The rule continues that this condition may not be imposed, or I'm sorry, this condition may be imposed only if there are no less restrictive condition or combination of conditions which would reasonably assure the safety of the community. This is the reason why the court spends so much time on those conditions of release, because the question is, are the conditions that the court has ordered enough to assure the safety of the community? And the court would like to be heard from both counsel about whether the conditions the court's imposed are sufficient or not, and then consider bail if the court finds they're not. Mr. Hillman.
The state's position is that they're not. You know, certainly, Your Honor has expanded, you know, the original conditions of release, but when you boil them down to their essence, it's don't have contact with Mr. Altheimer and don't engage in activities to surveil him or intimidate him. And we know from the evidence that was presented in the court's findings that Mr. Troyer was unable to abide by those conditions when he was released on personal recognizance. And in this instance, the state's asking the court to set bail to better ensure that he does follow them between now and October 31st.
Mr. Sharon?
I think the court's made clear what it believes with respect to the conditions of release that it will be imposing. I'm going to go back to something I said earlier, which is a $10,000 bail is a penalty. That's all it is. Counsel for the state said, no, if he violates the conditions, then he loses the $10,000, but that's not true. You don't forfeit a bond that a bonding company posts if the conditions of release are violated. That doesn't happen. So it's not like if the state brought some other motion and alleged some new violation that the $10,000 was actually at risk. So really, what are we talking about here? We're saying it's not like Sheriff Troyer's not going to post it. Let's not kid ourselves. It is a question of, does the state get to punish him and impose a tax on this? And the court's conditions that the court has, and this hearing has made perfectly clear to Sheriff Troyer what the conditions he has to abide by. And imposing a $10,000 bond on it, adding that to it, is not going to increase or decrease the chances of anything else.
Well, I'm looking at Criminal Rule 3.2N, and it says accused released on recognizance or bail, absence, forfeiture. And it certainly says that the accused has been released on bail and fails to appear for court, that the bond or the bail can be forfeited. But it also says or violates conditions of release, that can also occur. And so I believe that that what Mr. Sharon said is incorrect, at least according to the plain language of the rule.
Mr. Hillman, there are certainly different types of bonds that an individual can post. And it's this court's experience that typically bonds of this nature are appearance bonds. And so where the forfeit occurs is if the person fails to appear, then potentially, and there's Washington law on this, there's potentially the bond would be forfeit. The bonding company has a certain period of time to try to go find the person. If they do within that time frame, the bond is not forfeit ultimately, and the case would go forward. But this case, at least the issues presented to the court in this case, this is not about Mr. Troyer appearing. The court has no concern whatsoever that Mr. Troyer will appear. This is about substantial danger to the community portion of the court rule. And so court doesn't recall ever seeing really what's a performance bond. That basically the bond would be that this person promises to do A, B, and C, and if they don't, then the bond is forfeit, and the bonding company would then be contacted. And it wouldn't be like a appearance bond, because how can the bonding, if there's an allegation that the person failed to comply with one of the conditions, the bonding company can't go out, get the person, and theoretically say comply, because you've already been non-compliant. So performance bonds are, I think, a completely different type of bond, and it's possible that the court's just unaware of this, but I'm pretty sure if Mr. Troyer is ordered to post a bond, it's going to be an appearance bond. And so while the rule says it can be forfeit, I mean, this rule is really clear. If the person doesn't perform as required, the bond can be forfeit, but I suspect the bond that will be filed on the bonding company is going to be an appearance bond, and I don't know if there's any even litigation about whether a court tries to forfeit a bond when a person appeared on an appearance bond. I'm not quite sure what the court's ability to do with that under the rule. So the rule seems to contemplate somewhat like a performance bond, but to be perfectly honest, this court's not a lot of experience with something like that. They've always been appearance bonds that the court's been following.
I'm the same, Your Honor. I've never seen it happen, but all I'm saying is that the plain language of the rule contemplates it and appears to allow it, but I would agree, I have not seen that.
Do you have any comment about Mr. Sheeran's statement that in reality, the court imposes a bond on this based upon the findings today, that really it's just punishing Mr. Troyer, and it's just a tax that he has to pay a certain amount as opposed to ensuring that the public is safe?
No, Your Honor, because even though it seems to be a rare occurrence, the criminal rule 3.2N appears to allow forfeiture of bail for violations of conditions of release in the future.
Anything else you'd like to add?
No, Your Honor.
Mr. Sheeran?
No, sir, thank you.
Mr. Troyer, through his conduct as shown in the record before this court, exhibits a great disrespect of this court's orders and the law concerning Mr. Altheimer and the administration of justice. Mr. Troyer's disobedience of court orders and the law will not be tolerated. Based upon the record in this case and today's determinations by the court pursuant to Rule 3.2D6 has determined that no less restrictive conditions or combination of conditions would reasonably assure the safety of the community and Mr. Altheimer absent the imposition of bail. Rule 3.2D6 says, if the court determines under this section that the accused must post a secured or unsecured bond, the court shall consider on the available information the accused financial resources for the purposes of setting the bond that will, 1, reasonably assure the safety of the community, and 2, prevent the defendant from intimidating witnesses or otherwise unlawfully interfere with the administration of justice. That rule requires this court to consider Mr. Troyer's financial resources, at least from information that would be known to the court, in determining how much that bond should be. And as I said, the focus is what amount of bond will reasonably assure the safety of the community and prevent the defendant from intimidating witnesses or unlawfully interfering with the administration of justice. Mr. Hillman, concerning Mr. Troyer's financial resources.
Well, Your Honor, he's obviously the sheriff of Pierce County, and he's been working as a peace officer in Pierce County for probably 30 years. I don't have any personal information, personal knowledge about his financial situation, but I think that those two things demonstrate that he has the financial ability to pay bail.
Well, this is an important discussion because the rule is clear that the court has an obligation in this circumstance to, if whatever dollar figure it might pick on a bail bond, that the accused reasonably has the chance to make the bail. And so some information needs to be presented to the court as to what that number could or would look like, so that at least Mr. Troyer has the chance to reasonably post that bail. Again, with the amount assuring the public safety of the community and preventing intimidating witnesses or administration of justice.
And the only information that the state has is his current and past employment. And I would ask the court to inquire of the defense as to any information about his financial situation that they would like the court to consider before determining the right amount of bail. But for $10,000, he can either post that cash or most likely a $1,000 bond.
Anticipated you might actually say that final part, and this is somewhat of a situation like the Blazina court with asking whether someone has the financial ability to pay or not. Court's not going to order Mr. Sheeran to make any statements about Mr. Troyer's financial resources. If he wants to, he most certainly will be given that opportunity, but the court is somewhat, because that could well have come from confidential communications, and that's not, I don't want to hear that if that's the case. So with that caveat, Mr. Sheeran, is there anything you would like to say about Mr. Troyer's financial resources with respect to a bond amount?
Your Honor's already determined that the court will be imposing bail, and so I'm not going to rehash any of those issues, but I will say that if the court follows the state's recommendation, Mr. Troyer, Sheriff Troyer, will be posting the bond.
The issue for the court on how much of a bail bond to require, as I've said, comes down to how much bail will reasonably assure Mr. Altheimer's safety and prevent Mr. Troyer from intimidating or harassing Mr. Altheimer or otherwise unlawfully interfering with the administration of justice. The court has found multiple violations, has found Mr. Troyer has committed multiple violations of conditions of release, and has given the explanation as to why the court came to that conclusion. Really, the issue comes right now, can the court trust Mr. Troyer to not violate any court orders, and can the court trust Mr. Troyer to leave Mr. Altheimer alone, and can the court trust that Mr. Altheimer is safe when Mr. Troyer is the elected sheriff? And that's really the question today. Can the court trust him, given the fact that that prior trust that the court ordered 3 times was abused? Mr. Hill, is there anything else you'd like to say on this?
No, Your Honor, other than I would note that, the maximum fine for each of these crimes is $5,000, and there's two charges. So the maximum punishment that could be imposed at the end of the case would be $10,000, which is the amount that the state's asking for to assure Mr. Troyer's compliance with the conditions of release.
Do you think the court is limited to the maximum penalty with respect to any bail bond that would be required?
No, Your Honor.
So Sharon, is there anything else you'd like to say?
No, Your Honor.
Court's going to take